All right, let's go ahead and get started. Welcome, everybody. Thanks for coming to our webinar. Um, the point of this webinar really is to inform all of you about a new law that has been passed and is going into effect in January, and that I feel like a lot of people don't know about. And it's something that I think everybody needs to know about because it's going to affect quite a few people, including estate planning clients. So that's why we invited all of you to come see our or to be part of this webinar. Um, the point of the webinar, or the new law that's going into effect, is called the Corporate Transparency Act. And we're going to talk a little bit about what the Corporate Transparency Act is for, why they created it, um, what the ramifications of it are, meaning what the requirements for you are in complying with the new law, and what the penalties are, and then what next steps you should take in order to start to comply with this new law. So the Corporate Transparency Act is a new reporting requirement that is going to be uh, required of all corporate entities. And so when I say corporate entities, the way they define it in the law is any entity that is formed by filing a document with the Secretary of State. And so that would include LLCs, that would include corporations. And when I say corporations, I mean either C or S filing corporations, limited partnerships, um, and probably includes even something as simple as the DBA, because you do file documents to create a DBA. So if you're even running like a sole proprietorship with a DBA, uh, reporting requirements may be required of you. So let's talk about what the Corporate Transparency Act is, how it came into effect. So the law came into effect as part of the National Defense Authorization Act for the fiscal year 2021. And the purpose, or the stated purpose of the law, is to strip US shell companies of anonymity that can hide illicit financial activity and finance terrorist activities. So they are looking to crack down on this on illicit activity, um, financing of things that the government doesn't want financed, like terrorism, human trafficking, things like that. However, the law is very broad in that it affects almost everybody. And so the law will affect most entities formed as part of estate planning, other than trusts. Trusts are not created by filing any sort of document with a Secretary of State. So trusts will still not have to report as a reporting entity. However, you'll see that trusts may need to report as part of owning one of the reporting entities that we're going to talk about. Um, the department that's billed with maintaining this and enforcing it is the U.S. Treasury's Financial Crimes Enforcement Net, also known as FinCEN. FinCEN's been around for a long time. They FinCEN is the department that um, regulates and watches over foreign bank accounts, requires foreign reporting of those foreign bank accounts and income, so that people don't get away with, hiding income in other countries. Um, so FinCEN's been around for a long time. This is just going to be a huge addition to FinCEN, that now they're going to be monitoring not just foreign bank accounts, but also uh, domestic US entities. Um, FinCEN is going to be creating and maintaining a database that will allow and hold all of the reporting information. As of right now, the database will not be available for public uh, consumption, but will be available to government agencies in their investigations or actions towards any of these stated like I said, illicit activities. Because of the reporting, the broad reporting requirements, it's going to affect nearly 32 million existing corporate entities. So that's going to affect almost everyone that's we're talking to today, and almost everyone in the country. Um, and in addition, they've attached and given some teeth to this law. So there are pretty significant, if not severe, criminal and civil penalties for failing to comply with the new law. So that's why we're trying to inform everybody. We don't want anybody to have to, fall into a category where they're paying penalties that they simply didn't know about. Uh, and so this is also not a one-time reporting requirement. This is an ongoing duty to report any changes in corporate structure. So let's talk about what actually needs to be reported. But if there is any change in what has been reported, there's an ongoing duty to report. Okay. So let's talk about what the reporting requirements are. The first thing that's going to be reported is the corporate entity itself. So let's talk about what is a reporting entity. Any entity that is created by filing paperwork with a Secretary of State. There are some exemptions that are listed. However, it's mainly for entities that are already giving this information anyways, like publicly traded corporations, and other regulated industries, like accountants and things like that, where they're already reporting with the government who owns those entities. So the information that the reporting company must provide is as follows. They have to give the legal name of the business, including any DBAs that it is using. It has to give a street address for the principal place of business. This street address cannot be a PO box or an attorney's address, must be the actual principal place of business of the company. Has to provide the state of formation of the corporate entity, the tax identification number for the corporate entity, and a PDF of the identifying documents, such as the articles of organization that formed the company. As of right now, there is no good faith defense to the reporting requirements. So ignorance of the law has never really been a defense, but even trying to say that we attempted to comply with the law, even though it is still very unclear and shady as to how many people need to report, there won't be any sort, as of right now, there's no good faith defense in trying to comply with this law. In addition to the reporting company that has to file, the company itself is also responsible to report and file reports for any what they call beneficial owners of the corporation. So let's talk about what that means. A beneficial owner is any individual that directly or indirectly owns at least 25% of an entity. Now, when they're talking about ownership of an entity, they're not just talking about equity ownership. The way the law is written, it seems to also include any sort of profit interests, convertible instruments, warranties, options, puts, calls, and even possibly debt instruments that could be recategorized as equity. This puts a big strain on the company to make sure that it is reporting for all individuals that may hold a 25% ownership interest in the company. Okay. So this is where it gets really difficult because a company it's going to report for itself, but it may have to report for dozens of other people that are involved with the company. There is an exception for a minor child. If a minor child is included as a owner of an LLC. However, once that child turns 18, again, there's a 30-day turnaround where you actually have to report now that that child is no longer a minor. So in addition to a beneficial owner, the reporting company must also file reports on any individual that is determined to be a substantial or determined to have substantial control over the company. We know that this is probably going to include the manager of an LLC, directors or the whole board of directors of a corporation, officers of a corporation. It also includes people that have power to appoint or remove any of those senior officers, and also states anyone who has authority for direction, determination, or decision of, or substantial influence over important matters of the company. That's pretty wishy-washy language, so it's difficult to know exactly where they're going to come out on who needs to report on this. So what we are advising is to over-report. So if anybody has these powers or might have these powers, better to report those people and not get hit with penalties later, but have them all reported. In addition, the organizer of any entity must also report, which is probably with my clients going to be me. So I'm going to have to report my personal information as well for any corporation that I create. That also has some issues that are mainly logistical for any attorney or accountant that is setting up an entity for a client. Many times I'm using a service in another state. So is that service then required to report somebody because I'm asking somebody there to file a document with the Secretary of State? Much of this is unclear. So we really don't know what they're going to require, but probably if you're asking your attorney or an accountant or some other advisor to form an entity for you, they will have to report as the organizer of that entity. So of all these people, the beneficial owners, the people with substantial control, and the organizers of the company, here's the information that they have to report to FinCEN. They have to give their full legal name. They have to give their date of birth. They have to give their home address, their personal residence address. This cannot be a business address, the address of an attorney, or a PO box, your home residence address. And also a PDF of your passport or driver's license or other government issued identification with a picture. Again, this puts a ton of strain on the company because it's the company that has the duty to report all of these people's information. So now these companies are going to have to go out, find this information from all these individuals and make reports. They have allowed for a process to make this somewhat more simple for the company. And that is for the individuals that are needing to report, they can go and also report the same information, but get what's called a FinCEN identifier. That FinCEN identifier can then be used as the reporting of that person for the company. So basically what would happen is if I own a company with some other people, instead of the company reporting all of my personal information, I would go onto the website for FinCEN, file my own information for me personally, get an identifier, and then so would all the other people that are involved with the company. And we would give those identifiers to the company to then report on the company's report. The reason this will probably be very helpful is because of the ongoing duty to report. So if there we go, lights went out a little bit. So if I change my personal information, so if I move or anything like that, I don't have to go and file with any entity that I'm involved with, which for me would be a lot because I'm organizing entities all the time. Instead, I can just change the information on my identifier. The identifier is already associated with those corporations and would change automatically there as well. So the FinCEN identifier path is probably going to be used pretty extensively. At least for us, we will use it extensively. The timing of this reporting. So the law goes into effect January 1st, 2024, coming up in about a month and a half. However, for any entity that exists before January 1st, 2024, you have all year to report. So your reporting is not due until January 1st, 2025. However, any new entity created will have 30 days to report, to make their report to FinCEN. That's not a lot of time, especially if you have a lot of people that you have to get information from. So there will probably have to be some timing issues involved to make sure you have all the information ready so that when you file your articles with the Secretary of State, you're also already ready to file with FinCEN as well. Remember that there's an ongoing duty as well. So if information does change, you have 30 days to make that change with FinCEN as well. Some of the things that are coming up in what I do in estate planning is how this will affect things like probate administration. So in a probate, someone passes away. Now who has to report on any LLC interest that was owned by the deceased? The executor that's named is going to have powers to do certain things. So does the executor need to file? Once it's distributed out to beneficiaries, you're also going to have to determine who needs to file as part of those beneficiaries. The other thing is do you have to report on multiple times on each of those transfers? So if the executor gets it and then transfers it out before those 30 days are even passed, does the executor still need to report for having had those powers for some certain amount of time and then transferring it out? That's unclear and has really not been addressed yet. Also, there will be some effects on trust, and here's where trusts come back into this whole issue. Trusts are not a reporting entity, but trusts own reporting entities all the time, like LLCs. So this is what they have issued as some information about who will need to report as part of a trust. It says the following individuals may hold ownership interests in a reporting company through a trust or similar agreement. So one, a trustee or other individual with the authority to dispose of trust assets. Two, a beneficiary who is the sole permissible recipient of trust income and principal, or who has the right to demand a distribution of or withdraw substantially all of the trust assets. And three, a grantor or settlor who has the right to revoke or otherwise withdraw trust assets. So there is some clarity there, but also some confusion. The clarity is that the trustee almost certainly will have to report, and they're going to have to report personal information. Someone that owns an LLC in their revocable living trust will also have to report. But then there's all these other things. One of the issues is, what about a trust with a corporate trustee? The corporation, the corporate trustee cannot be a reporting person because it's not a person. So you're going to have to get down into who is actually controlling the trust and the LLC. So it may just be the trust officer. It may be many officers in the corporate trustees corporation. That's unclear. You also can divide out powers into trust. So will an investment advisor need to report? Will a trust protector need to report? People that hold powers of appointment, they can withdraw assets. What is withdrawing substantially all of the assets? All of these are unclear and have not had time to go through courts or anything like that to give us any clarity. We also tend to use things like crummy powers for a lot of our planning to allow for gifts to be complete. Will those people need to file? All of this is unclear. So that's part of why we're just letting you know that this is out there, and there are some issues still that need to be resolved. And it's not going to be as simple as just filing your name and address on a website. So with FinCEN, we talked about there being penalties. The civil penalties are $500 a day for not reporting, up to $10,000. And then the criminal penalties is even up to 2 years in prison. They have suggested that they give some 90-day grace periods, especially since it's a new law. Those have not been allowed yet. So right now, if you're not complying within the 30 days, those are the penalties. So $500 a day is no small penalty. So then the question, what do you do now? Our suggestion is to start now. We know you have entities that exist now. We know the reporting's not due till January 2025. But again, this is not going to be something that's just a quick reporting job done. So start now. Don't wait until the end of next year. Get advice and counsel early. I think the quicker you can start looking into this, talking it through with your attorney and other advisors is very important. Start compiling a list of the interested parties, and then have the interested parties start obtaining. Now the website's not up yet, but once the website is up yet, have your interested parties start obtaining those FinCEN identifiers. That's really the information I have right now about the Corporate Transparency Act. Again, it's a law that not too many people know is going into effect, but it's going to be quite burdensome once it does. So I'm glad that you guys were here to talk about it. The question and answer portion is up and going. I'm not seeing any questions yet. I know this is a lot of information to take in, but feel free to jump on there and I'll wait around and see if any questions pop up. But again, thank you for taking the time to talk through this with me. And if you have any questions in the future as well, feel free to reach out to the office. Yeah.
Thank you, Blaine, for the presentation. Like Blaine said, we'll leave the chat open, question and answer open for a few minutes. But thank you for attending today.
So Hal asked, if a person's driver's license or passport changes, do they need to update? It depends on what you mean by changes. So if the address changes, yes, you'll have to update, and you have 30 days to do so. If the number changes, right? So if my passport number changes, then you would have to update. I don't know if you're just you're renewing your passport or your driver's license and there's now a new date on it, whether that has to be loaded, added as well. I would definitely want to make that report and not be the one that makes the mistake of not making that report and getting hit for the penalties on that. Okay. Oh, we have a question. Oh, we got a few. It scrolled down on me. So I got a couple questions. What happens when a 25% owner is a revocable trust? Who gets reported? So again, the revocable trust, if the trustors are still alive, then the trustors are the owners, right? So like if my wife and I own 25% of an LLC, we, being the trustees of our own trust, would be the reporting people as part of that. Now, if something happens to us and we become incapacitated and now there's a new trustee, that trustee would probably also need to report as well. Where can we find the website to report? Yes, the website's not up yet. FinCEN has a website set aside. You can go visit it, but It's just some basic information right now. We haven't really seen what the website is going to look like as far as when we're inputting the form. But we will keep you updated with that information as we find it. Give me just a second. There's another one here. Do you have one page? Is this just from here? Or is that the chat? There's the chat and there's the Q&A. So I'm going back and forth. So right now I'm in the Q&A. I'll jump over to the chat here in a second. If we Google the Corporate Transparency Act, can we get more info regarding directions on how to report? Yes. And we will send this information out as well on our emailer. They have issued a small company compliance guidebook. That's a PDF that gives a lot of this information. That's where I grabbed a lot of this information. So feel free to look on the Google the Corporate Transparency Act and find that small company compliance guidebook. All right, let me jump over to chat. Okay, please repeat the 3 that have to report for trusts that own reported entities. Okay, so we know that the trustee will have to report. Beyond that, we're not exactly sure. Now, with a revocable living trust, because the trustors can revoke the trust, they will also be reporting individuals. So the trustee of any trust, the trustors of a revocable trust will definitely need to report. Other than that, it's going to depend on what powers they hold and how they are able to influence the reporting entity. But that could include an investment advisor, trust protector, someone that holds a power of appointment, someone that has a crummy power, even maybe someone that has a substitution power. So that's something you're really going to have to go over with your estate planning attorney to figure out, because trusts do kind of divide out powers in all sorts of different ways. But for someone that just has their revocable trust, nothing has happened, definitely the trustees, definitely the trustors. Back here. Okay, we got that one. All right. As I said, this is an ongoing issue. There's nothing about this webinar that's absolutely final or anything. And even, this is just informational to allow you guys to know what the law is, that it's out there, that it's something to be looked at. Feel free to reach out to our office. Feel free to ask us questions about this, because, as I said, we're going to continue to watch this, see how the reporting goes into effect starting next year, and we're going to we'll be helping our clients to report if they ask us to. So we're going to be on top of this as well. So please feel free to reach out. Thank you again for being here and for listening to the webinar. We are here to help and to keep you informed. So again, we're watching all the reports, all the articles, and any of the new news that comes out about this. So we'll try to keep you up to date as much as possible. But thank you again, and have a great afternoon.